We're live now.
Okay, great, we are. Welcome, everybody. It is Tuesday, May 13th, and we are in Senate Economic Development, Housing and General Affairs, and we are looking at a bill we left off working on Friday, which is H106, an act relating to selling real property within a FEMA mapped flood hazard area. And to pick it up, we are going to look, there are a number of concerns about the language that we were sent from the House in terms of the burden, perhaps, is it a fair thing to say, perhaps the undue burden put on the sellers to identify an accurate flood map and the ability of sellers to actually be able to secure one. And so we are going to look today at H106 as introduced, Act 181, which had the language in it that was fairly prescriptive about what the disclosure form for sellers, and the bill as sent to us from the House. And I'm hoping we'll find a landing spot on what we agreed to. Cam, that
works for me.
Tee us up? And we had left off on Friday with various concerns about the language, whether people could live up to the language that was sent to us from the House. Is that a fair way of putting it? So, because the failure to, on behalf of the seller's failure to provide these was harsh. So, Peter and Tucker, if you would be kind enough to sort of remind us where we were in this discussion.
Oh, Peter and Tucker.
Peter and Tucker. I know, isn't that funny? Cam,
yes.
Would you be kind enough to sort of remind us where we were and the areas we were reconsidering?
For the record, Cameron Wood, Office of Legislative Counsel. Madam Chair, if you want, I'm happy to kind of start with what you passed last year. Maybe it's a good starting point. We can review some of the sections that were in Act 181 and then talk about the conversation from Friday.
When you say passed, do you mean that the Senate passed or that came out of the conference?
Just what was in the bill.
Just what passed?
But, we
didn't have a conference
General
committee.
Act 181.
Right.
Does it help to look at what passed the Senate?
I think we probably.
It was.
Yeah, Peter.
Yeah, sorry, Peter Tucker from Vermont Association of Realtors. The language in H106 is actually the language from Act 181, the pertinent section of 181.
Right.
So, you can look at one or the other. They're going to be they're the same language.
Are they?
I don't, but I think what Senator Ron Hinsdale's asking, and I don't know, I would have to go hunt it down to find it, is what you all may have passed out of this committee. I just have what was in 181 as passed the General Assembly entirely. And there's a few sections here. We've kind of walked through 106, so I'll be a little brief on this section 102 because as Mr. Tucker just mentioned, it is what is in 106. So prior to the conveyance, or as part of a contract, the conveyance of the property, the seller has to notify the buyer whether the property is in a FEMA mapped area, whether the property was subject to flooding, and whether the seller maintains flood insurance on the real property, which is what we were talking about last Friday. And then you have, under B, it's grounds to terminate the contracts. If the buyer fails to receive the information, can bring an action against the seller for damages and reasonable attorney's fees. The buyer can also seek punitive damages when the seller knowingly failed to provide the required information. And then the seller's not liable if the error, inaccuracy, or omission is based on information provided by a public body or another person with a professional license or special knowledge who provided the written report to the seller. Non-compliance doesn't affect the marketability of the title. What else did you all do in Act 181? There's a few sections I'll just run through very quickly. You added a provision to require that a landlord disclose to a tenant on a rental agreement whether the location of the unit is within a FEMA map special flood hazard area. This Department of Housing and Community Development develops a model form for the notice provided, so landlords have to inform tenants if they're in a FEMA mapped special flood hazard area. And then in the mobile home space, you require that a mobile home park notice an individual who's going to lease if the mobile home park is wholly or partially located in a flood hazard area according to the flood insurance rate map effective for the mobile home park at the time, the proposed lease.
Right.
Not quite sure why there's a little bit of different language there, but, and then the last thing you added was when selling a mobile home, in the case of a mobile home, the seller shall provide a prospective buyer with written disclosure of any flooding history or flood damage to the mobile home known to the seller, including flood damage from inundation or flood-related erosion or landslide damage. So you passed all of these sections in 181. Seller of real property has to notify a buyer of those 4 things. Landlord has to notify a tenant if they're in a FEMA mapped area. Mobile home park owner has to notify mobile home lease owner or individual who's going to lease the lot if part of the mobile home park is in a flood mapped area. These are all things that were in 181.
That's kind of why I wanted to look at the language we passed, because we
Was
did
it that
very
different?
different. Oh, yeah.
So H106 as introduced got rid of the first 2 requests.
That is correct, yes.
And that's,
Yes, ma'am.
is that all?
So I have that here. So 106 as introduced removed those 2, whether the real property is located in a FEMA mapped special flood or moderate flood hazard area. And then it also had it being applicable retroactively, which creates certain legal problems.
I mean, under the effective,
Right here, I'm sharing my screen. 106 as introduced had a section 2, so it's a claim arising from the failure of a seller to provide the information shall not be eligible for damages. So as it was introduced, again, it's removing the requirement to notify someone that you're in a FEMA mapped area. But under current law, they're required to do it. So what do you do in the event that someone fails to comply with that requirement? A prospective buyer has the right to damages at that point in time if the seller hasn't complied, because this is current law. So as it was introduced, it applied that retroactively. It applied the removal of the requirement retroactively, which I had to inform the House General Committee potentially creates certain constitutional issues.
oh, yeah, that creates all.
So the House General Committee, as they were discussing, they wanted to kind of move away from those potential legal concerns, and where they landed was we will still require the disclosure. We're not going to remove it and make it retroactive. We'll still require the disclosure, but we'll beef up the defense, and that's where they added the language that you have in front of you as was passed, where they included that
In C and D,
in, this would be in D2.
oh, in D2, right?
If the seller, after a reasonable attempt to identify whether the location is in a FEMA map special or moderate flood hazard area, notifies the buyer that the seller cannot reasonably determine and notifies the buyer of the requirements of the section. That's kind of where they landed, was just instead of removing the requirement and dealing with the retroactivity issues, just expanding the defense that a seller can rely on if they're unable to determine whether their house is located in that area. So then on Friday, your discussion started to kind of then center around whether or not you should put this requirement on a seller. And remember, we started discussing what does reasonableness mean, and would you go away from reasonableness? And I kind of caution you against that, because I think you would have to get extremely prescriptive. If, you know, if the map is this way, then the seller needs to do this. If the map is this way, then the seller needs to do that.
And I think you said that reasonable was a term that's used often in law, and that, I mean, it's not defined here, obviously, but it is.
No, but a court
It's
will look at the
understood in
facts.
court.
Yeah, a court will look at the facts and determine whether something is reasonable or not, either a court or a jury. And you know, it is a term that is used frequently in other legal areas, yes. Again, as we kind of discussed, if I'm and I was kind of mentioning to the committee, the sub 1 here on the screen that I'm sharing is already in statute. If I'm the seller, the best way you can protect yourself is you reach out to the town or you reach out to someone who is a professional, you ask them, you get a written response, you provide that information to the buyer. Because currently, if there is an error, inaccuracy, or omission based on information provided by a public body, by a person with a professional license with special knowledge who provides a written report to the seller has a defense already.
Sorry, and which one is this?
This is one. This is what's already in statute.
This is current statute.
And so that's what I would do. But I mentioned to you all, I fully understand that, you know, many individuals may not be aware that this is in statute. And so the House General Committee was receptive to adding the subdivision 2, which is, you know, a little more, you know, if the individual isn't relying on a town or isn't relying on someone with a professional license, but they've made the attempt, they can determine, because the map doesn't exist, or as you saw some of the maps from last Friday, they simply can't ascertain whether their property is on the map and whether it's within the line.
Couldn't, in whatever all that is, couldn't we just say the seller is not liable for the accuracy and readability of FEMA maps?
I would potentially want to change it if you did it that way, in the sense of
not now or never. You know, like maybe that's just a good provision to apply all around.
So right now you have it that the seller has to notify the buyer if the property is within this map.
Right, which we'd hopefully take out, right? The proposal going back to 106 would be that you have to provide the website link and that you need to let them know if you're required to carry flood insurance.
And you could do that, right? So that was
So
some
if
of the
you did
conversation
that-
on Friday. Number 4 is already there, whether the seller maintains flood
Right.
insurance.
So if you
could
struck
take-
the other 2, but you still require the link to be proffered, I think it's good housekeeping looking backward and forward to just remove responsibility of any party from having to interpret the FEMA maps.
And so that was the discussion you all were having on Friday, was whether it
Right.
should be the responsibility of the seller to provide this information, or
So
to provide
how would you
their
change the
interpretation.
language that I just proposed?
But you could take 1 and 2 out, and you could just say, if you wanted to keep some sort of obligation on the seller, you could say the seller has to provide the buyer with either the FEMA map, if one exists, or, you know, the location to it electronically. I mean, you could.
But then we're talking about the retroactivity piece.
No, you don't.
I would get rid of,
We don't need that.
Okay, but would it
well,
be how, like, that's the thing, with the retroactivity and going forward,
we don't have the retroactivity in this, in as passed by the House.
Real quick, the
Yeah.
issue is this. You could change the law and you could make it prospective if you wanted to remove this requirement. What you potentially have to deal with, or you have to understand, is this is the law right now.
Number 1 is.
All of them. Providing this information is an obligation of the seller, and if a seller is not providing this information, then a buyer has a right currently to bring an action against the seller if the seller hasn't complied with the law, and bring a claim for damages. And so you're not going to get around that unless you want to change the law and apply it retroactively, in which case you then bring in constitutional questions.
Right. No, I think the
because that is an
retroactivity
ex
piece.
post facto law that is changing an individual's rights and remedies under current statute. I think that, and I've had conversations with some of my colleagues in Ledge Council about this, I think it's defensible to do that if you so choose, but a court might find that it violates the Constitution and you strike it down, in which case individuals who are selling property right now between when this law went into effect and when you potentially change it prospectively going forward, individuals within that window would have rights.
Peter, you had something you wanted.
Yes, so the retroactive nature or language in H-106 as introduced, because of, Camp's constitutional concerns,
Right.
we would ask that not be included. Sellers in this period of time from the veto override last June until this new language is passed are going to be exposed. To what extent, I'm not certain. And one of the challenges with something like this is that, buyers may want to bring action for any number of reasons, but this would be the tool that they would use. But we don't have a solution that I think would hold up to constitutional questions, to address those folks. At the same time, Jim Knapp, who you heard from last week, has said, look, if you change this and it prospectively goes forward, the very fact that you're saying, now we've realized FEMA maps don't work and, and folks going forward will not have to meet that requirement, could be used as a defense of a seller who was unable to determine during this period of time, June 18th to whenever this bill passes, that would be their defense, would be, look, the legislature changed the language and, we told you we couldn't do it up front, but,
Well, should we perhaps, and would this be of any value to solve that problem, if we made some legislative findings that the maps didn't work, that they were inaccurate and not to be relied upon?
But they're accurate in some places, like,
In
we've
some
heard
places, but
uniform
not universal.
is not.
it's not universal, it's true.
not universally accurate, perhaps is a better way of putting it.
But
But again, if
certainly
we put it so that there's a clear finding of, we're changing this because this, would that be less likely at least to make to create a case that relied on those?
If you're not doing anything retroactive, then you don't have anything to worry about.
Yeah.
However, I do think if you're going to do something retroactive, either you're going to remove the requirement of 1 and 2, you're going to change the requirement of 1 and 2, or you're going to make those retroactive, or you're going to add a defense that is retroactive, etc. I think it is probably best for you to put some sort of finding in there to indicate why you're doing it, because that will signal to the court.
Correct. And again, we don't have to do anything retroactively, because I understand the problem with that. We're changing it going forward, but the finding explains what we're doing, or
Yes.
what we find, or we find it not entirely reliable, or whatever wording we want to use.
Yeah, if you, I think that it is not going to hurt if you wanted to say, we're amending this law moving forward because we're
The
finding
last
that the FEMA
legislative
maps
session
are
foolishly
XYZ.
added this thing.
I wouldn't draft it that way, but yes, sir.
No, we wouldn't do that. So required now is they do have to disclose if they carry flood insurance or not, right?
Yes, ma'am, that is in the 4 line 17 here, whether the seller maintains flood insurance on the property.
Right, and that's current law in D, which, right, so just remind us, the things they needed to disclose now are whether or not they have flood insurance,
Whether the property has flooded while the seller
whether
owns
in
the
their
property.
ownership, in their period of their ownership,
And then whether the property's in a FEMA mapped area.
right? As best as, and that's the question, is we could qualify that.
Right, yeah, they're required to notify, and then the question becomes, what if they can't tell? And what does the law give them, are there defenses? And there is one defense currently, and this proposal would be adding this additional language.
Right, if they've made the reasonable effort.
Because
Okay.
technically, right now, a seller, I don't want to say a seller can't say, I don't know. A seller could say, I don't know, to a buyer. They might be opening themselves up to a potential claim for damages if they're not relying on the current language under 1.
Peter, so
I think ultimately the decision you just have to make as a committee at this point is whether you want the seller to continue to have this obligation. What level of obligation, the specificity of the information you want them to provide.
I'm gonna go back to what I said before, which is, I think, I'm looking back at least our intent when we passed this language and our intent in clarifying this language. And it was never for, and you all could disagree, but it was never for the seller to have to be able to vouch for the accuracy of FEMA maps.
Right. But it was for disclosure. I mean, we wanted to make sure that every buyer knew that a property, either to the best of people's understanding, had either been flooded, they had to pay flood insurance. But you're right, that to have to vouch for a map that they don't,
It had been, let's just stick with had been flooded for a second, because we had a lot of debate about what it meant to say had been flooded. And let's look at current law. So under current law, I'm kind of asking Peter, I guess, under current law, there's some practices now that would require that a seller disclose water damage. And there's encouragement to get your own housing inspector to verify that the level of damage, is commensurate with what the person reported.
That's Peter Tucker for the Realtors, and I think that's well said. And then, there are a number of issues, right, with properties, the high winds that damage roofs, flooding that occurs, water damage not as a result of flooding, still is a material fact that should be disclosed to buyers.
Mm-hmm.
And that is what we're always, trying to do. It's really hard to define, all of those material facts. So we've kind of done this one at a time, if you will.
yeah.
Well, as I look at this, it says whether the property was subject to flooding or flood damage. Now, what does that mean if you have a 56-acre property and you've got an acre of wetlands, half a mile away from your home, and your home is never flooded? What does that mean, and what does flooding mean?
And the definition is real property, which
It's real
includes
property,
land as well as improvements.
So land, if you're talking about land,
That,
what, you have to disclose this.
yeah.
I mean,
well,
I actually had one
With
member
56
bring that
acres.
exact question up.
Yeah.
With 56 acres, people might well want to be building on some of it, so you do need to know what has been
Nobody's
subject
gonna
to
want
flooding.
to build on the pond that that's the wetlands I'm thinking of, but.
Not
So-
to muddy the waters at all,
As
but
it were.
this is what you all, the Senate initially passed in H 687 last year.
Muddy the waters, I'm sorry. Go ahead.
Yeah,
Right.
So, Senator Ron Hinsdale was asking for what was information that came out of this committee or came out of the Senate specifically, and I have not tracked back the history of this legislation.
but this is what passed out of the Senate.
I went very quickly, I grabbed, 687, which is what ultimately became 181. I looked at what the Senate proposal of amendment was, and this is what the Senate proposal of amendment was related to this section. So it was just sub A, it's got the other pieces of the section, but it was only the seller shall provide notice to the buyer whether the property is subject to a requirement under federal law to obtain and maintain flood insurance on the property. That was the only piece that was required under this section initially coming out of the Senate.
And that's what other states do, and that's what we like. No?
I have not done the independent research of what other states do specifically, so I don't.
Sure, and I'm happy to respond to that.
Yeah.
I'm uncertain, but it is certainly not, there's, some states may have, other flood disclosure requirements, but, I'm not aware exactly how many or what they look like.
So this would be in lieu of, that we keep one, and then,
It would be, if you wanted to go back to what you all passed last year, it would essentially, my recommendation would be just removing 1 and 2.
from D1 and 2.
From A. A1 and 2, which is the requirement of the seller to notify a buyer of that information. If you wanted to go back to what you all initially passed last year out of the Senate.
And that's not what H106 as introduced says.
H106 as introduced did remove 1 and 2.
It did remove 1 and 2, but it didn't replace it with, it it does have whether the seller maintains flood insurance on the real property.
And that's in the 4 here.
Right.
I would potentially reword that slightly.
Replace it with what our language was originally.
Potentially, I just, whether the seller maintains flood insurance,
It's
I think.
required. I think
I'm
it would be better that whether they're required.
I'm
because they may
assuming,
not.
yeah, your maintenance of flood insurance may depend on whether or not you currently have a mortgage, et cetera,
Yeah.
so.
I mean, if we don't look at another state's language, we could be spending unnecessary time, but what we were told over and over again is it is the requirement to carry
Right.
flood insurance. So if we want to look at the language of another state, that might be helpful to just not do anything truly, a lot of real estate transactions are interstate and people are used to uniform laws in these areas, or else there are problems. So I don't know if we want to actually look at the language of another state, but otherwise we should stick very closely to the language that I think the federal delegation expressed to us exists.
Which was required, which was the language we had in our bill.
Required to
Right,
carry.
as opposed to maintains.
Yeah, that seems
So I,
inappropriate right now.
right. What I guess
Sorry about that.
what I'm hearing is that as we take H106 as passed by the House, we would get rid of, Cam, what are we'd get rid of D2.
Yes, ma'am. So I'll go back to A. Let's start at the top. If you're wanting to go back to something similar to what you all initially proposed or passed last year, it would probably be removing 1 and 2. So the seller would not be required to identify whether the property is located in a FEMA map area. You would keep 3, whether the property has been subject to flooding or flood damage while the seller possessed the property. I would probably go to some version of 4, whether they're required to maintain.
I think the
flood
required
insurance,
language is what we
right?
probably want, the language from last year.
And then the question is, I would go back to probably what you passed last year regarding D1. I'm not sure what the defense was. I'm not sure that you need the D2 anymore. If you
Right.
remove the requirement that they notify that they're in a FEMA mapped area, you don't need D2 as a defense.
Right.
And then again, you just would have to, assuming that version were to be what passed by the body, again, it's my job to just make sure you're all aware that there would be a period in time in which individuals would be able to bring a claim. And you either accept that or you can deal with retroactivity pieces to try to address that. But that would be up to you all as a policy decision.
So currently, there's a retroactive aspect to this.
No,
There's none.
not currently,
Contemplated.
not as it came to this committee. I'm just, if you're reverting back to how the bill was when it was introduced, where you're gonna remove the requirement to notify that they're in a mapped area, you either just apply that prospectively and just understand that some people may have a period in time in which they can bring a claim, and you just accept that as that's what the law was at the time. If you don't want that to happen, you would then need to deal with some retroactivity application. But
Would you need to deal, and again, I'm sorry I was out of the room, would you have to deal with the retroactivity directly, or would findings have sort of an intermediate effect? So that it again puts on notice the legislative recognition that there are issues with the maps without being specific, thereby discouraging such suits.
If you wanted to make it such that someone could not bring a claim for failure to provide that information as is currently required, you would have to make it retroactive.
So you'd have to say failure to provide this information.
You would repeal the 1 and 2, you'd repeal the requirement, and then you would make the repeal retroactive. So it went into effect at the time the requirement went into effect.
Which
And
is what,
And then ex post facto law?
that's,
There isn't, yes, but as you know, with many constitutional provisions, it isn't a 100% prohibition.
Mm-hmm.
Typically in the criminal context it is.
Mhm.
But this isn't a criminal context, this is, civil. And so I don't have the specific test in front of me, and we can, I could bring it, we can chat about it. The court's gonna look at, essentially what are your policy, what is the public policy the legislature is trying to enact here? Is it compelling? And that's where I think findings would be helpful to come into place for you all to say,
Our intent.
here's the
Right,
issue that we ran into, here's
Yeah.
why we're doing this, here's why it's important public policy to do it, et cetera. And then at that point, I think it's defensible. I can't guarantee you that a court is not gonna find that.
What
it
you want to
doesn't-
try to do is give someone, some cover.
Yes.
And I think the findings is sufficient, and you have made it clear going forward what the law is.
so. I'm just trying to pull up where we are at the moment. Sounds like we'd add findings to this. We'd strike 1 and 2. I'm just, committee, just tell me if we'd strike 1 and 2. We would add our language under number 4 about required, whether or not the property is required, the real property is required to be insured,
Right.
but a FEMA insured. And we would strike number 2, D2,
Yeah, I
It's
don't
not
think you-
FEMA insured.
Yeah, I don't think you need.
flood insurance.
I don't think you
Rather,
need.
it would be, they would require to get flood insurance.
And then you would remove D2, I don't think you need it at that point.
Yes.
Peter,
Yes. And if we can make the effective date, that's.
and the
September
effective
1st.
date you're wanting to be September
September
1st,
1st,
Of
In
this,
time.
of 2025.
yes.
in
Just
order
give
to
us time
update your
to
brochure.
Do our form work that we need.
Are we doing findings?
Yeah, I think yes, short findings on why we're doing this.
Again, here's where you all need to give me a clear direction of where you would wanna go. You can make it prospective, in which case, I don't think you have to have findings, it wouldn't be a requirement. If you wanted to indicate to the public why you're doing it, nothing wrong with that. But you're also not doing anything retroactive, so
Right, so
you're not.
can we make it
concerned by it.
prospective, and why can't we just do that?
You can, you absolutely can, I'm just informing you that if you do that, there is a period of time in which people would still have the potential claim because of the requirement that exists currently.
Right.
I'm not saying you have to do anything with that, I'm just making sure you're aware.
So intent language you think might help if a case was brought?
No,
I thought that's what I heard you say.
only if you're making it retroactive.
Okay. Okay, sure.
I don't like findings. I just don't like findings. Not
She
what
doesn't like
Senator
task
Sears.
forces, she doesn't like
Senator
findings.
Sears gave me a disdain for findings
Yeah,
because I
she
think
did.
it would add a lot of work for you that we would have to wordsmith for very limited gain. But I do think because we would still be requiring the link to be proffered going forward, and all of our heartache about this has been because these maps are so difficult to interpret,
And inaccurate.
that I think we should still put in a provision that I think would give the courts a sense of our intent going forward, and thereby looking back, that we do not want the seller to be liable for the difficulty of interpreting a FEMA map.
So,
Hmm.
two things there.
Yeah.
One, just let me know if you want to include the seller, you want to include a requirement that the seller at least provide the map, not whether the house is located in a FEMA area.
I
but
thought we were
here's
doing the
map.
link.
You and I'm sorry.
Oh, well, I'm
Peter,
sorry.
for the
We
railroad
haven't
stuff.
talked about a link. I mean, I
Yeah.
hear you two talk about a link, but what do you mean by putting in a link? That's an unusual thing to put in the statute, isn't it?
Well,
It
access,
would just,
yeah.
yeah, it would just be the seller would be required to provide, I would draft, if I were just on the fly drafting this up, I would say I would remove 1 and 2, and I would say the seller is required to provide the buyer with the FEMA map or the location to the FEMA map
I think that's good.
electronically.
Yes.
And
I
not
think that-
whether the property's in a FEMA mapped area, just you have to provide the FEMA map of where the property is
So
located.
the reason I'm bringing this up is because I looked at that map and saw effective 2013, right? Like, it's very hard to understand, honestly, for all of us, what we're looking at and what level of accuracy it has. And I really worry that this entire, like, right now, you have to disclose flood damage. You have to disclose any water damage to the property. So if we're gonna keep in this requirement beyond the requirement to maintain flood insurance, that's the only truly accurate required thing, because someone has already said, like, hey, according to our interpretation of this map as some kind of authority, you're required to have this insurance.
Right, but
If we extend it to saying you have to provide a link to the map, I do believe we should curtail the exposure of the seller in terms of any interpretation of what that map means.
and it would include all the FEMA maps, whether they're current or not. I mean, it would.
They're not current.
Well,
In
some
fact,
are.
no, they are not. Because-
Can I make one comment on maps? There's a guy that came out of a profession
Yeah.
that lived and died by maps, charts. So maps are only as good as experience allows us to update them. So in the Navy, we would typically use maps, they could be 100 years old.
Right.
But at least they give us a sense.
Yeah.
It's up to us to interpret. So I think providing the fact that the maps exist.
Yeah.
Providing either a copy of or a link to the source, which you don't maintain.
Yeah.
Is good enough. You're not gonna get any better.
Right.
So,
I agree.
bad mouthing maps, it's not gonna get you anywhere. They're as good as they get.
Yeah.
And they get updated all the time.
These maps don't.
Well, we
Unfortunately.
But
heard,
they do when they can.
Yeah.
When new information comes out and they have the resources to update them, they update
So-
them.
I think that
If
we
I could just say, just so we don't confuse people on the record, or people don't misinterpret what I'm saying. What was very difficult to hear is that FEMA was going to work with the state on new maps, and they are doing that right now. And those maps would not include any of the flooding events of the last 10 years, even when they say updated to 2025. That data would not be available for the maps that would go into effect more recently. They would be using data, hopefully post Irene, but that wasn't true in all areas of the
Right.
state.
But it
that's
still
correct.
provides an indication that there's a risk in the
Right.
immediate area. And you're not gonna
And-
get any better than that.
And the maps have dates on them. So but I think requiring that they provide the link. is good.
So that's one other thing that was mentioned on this. I know what you're asking me to do, and you all understand. If you make it prospective only, even though you're making the change, and the court will understand that you're making the change, they're going to apply the law as it was at the time that the property was sold. So if you're not gonna do anything retroactive, you're not protecting the sellers that sold property from when Act 181 went into effect to when the change that you're proposing goes into
And
effect.
that's a what lag?
It's, this went into effect in
July of 24.
June of 24.
June of 24.
to-
So till September, it's a year and a half roughly, or a year and a bit. So for a year and a bit, we will not be protecting sellers.
I wanna be careful how I'm wording it, protecting sellers or
Well,
not.
I-
You know, sellers will have, yes ma'am, sellers will have the obligation that currently exists. And if they didn't comply during that time, they're open to a claim for damages. And that's current law.
And if you don't want to do it retroactively, your option, at least to prevent an injustice, which that might be, is to have a finding that the maps that we essentially find that the maps are not universally accurate, in some cases provide misleading information. The legislature was dumb to act as part of the law in the first place.
Again, you can put that in there, it's just, it's not,
It's not
It's not
bulletproof.
gonna further protect
well,
us.
well, no, I'm just saying it's not a, I don't wanna be flip here, a court's not gonna care.
Mhm.
They're gonna look at it and say, that's great that you changed the law going forward,
But
because
this was
you all felt
required.
that it needed change, and it was incorrect if you feel that way when it was initially passed, but it's the law. And
Right.
so, if you seller didn't comply,
And your feeling, though, is that since this is not a criminal situation, that you
Listen.
could do an ex post facto.
I think you can apply it retroactively. There is an argument to be made that it will be upheld by a court. I can't guarantee you that outcome.
Retroactively till June of 24.
Mhm.
So what do we feel?
I don't think, I just don't think we can do anything retroactive, frankly. It's not, we don't want to be bad lawmakers. And like,
Speak for
If we-
yourself.
I mean, I can just see,
Just kidding.
I can see so many scenarios where we wish we could do that. We have, I mean, sitting on finance, we've applied some kind of forgiveness or abatement if we really felt we were in the wrong, although we honestly have barely done that. It would be not good lawmaking to say, like, just kidding, we made a mistake and the last year and a half of laws don't apply.
So, Peter, you have a thought?
Just what I wanted to say is, we don't want to create a constitutional crisis here.
No,
Right.
By
there are
asking for
enough constitutional
retroactive
crises
language.
at the moment.
I do actually prefer Senator Brock's, just a very brief finding statement at the front end of this. And I think that an attorney who was defending a seller during this period of time would, be able to say, look,
refer to it.
legislature changed this because we realized how ineffective they were. And that's really what happened.
Or
right?
inaccurate, not ineffective.
We put it into practice and then we started to find out how inaccurate.
Ineffective,
So,
Well, point
And I
one
think
for
that warning-
findings.
Right,
That
right.
warning, I think a court would read that warning.
Yeah.
well,
if nothing
and
else.
we've been told before that actually courts look at the intent as opposed, disagreeing with Dick's ears, because I have heard that the courts actually do look at intent. So would you be willing to redraft this with a very short findings?
But, well, then let's be really clear, though. Findings and intent are very different.
Intent.
Are we do we have
No.
a finding?
I think intent. I
Okay.
think our language is around intent, why we're doing it, why we're making this change. And then including, getting rid of 1 and 2, adding, expanding on number 4 to be required to go to our language or some version of the required, flood insurance. And then getting rid of 2
I'm not trying to be difficult. I just want to cover our bases.
and then expand, sorry.
We were willing to listen to the argument last year that we would create a greater set of protections for renters and mobile home park residents. But I do worry that if we are saying that we find that there's a lot of subjectivity or whatever we're saying in this arena, it does become incongruent for the other sections, which is why I wanted to look at our old language, because I don't want a renter or a mobile home park resident to be knowingly or unknowingly lulled into a false sense of security that they know something when they don't. The same way I don't want people to read too much into someone saying, that they know they're in a FEMA flood map or not. I wonder if our current renter and mobile home park protections, if there's something else they could require that's more similar to what a homeowner has to disclose about flood damage.
So if you're selling a mobile home itself, you only have to disclose
It's
whether
the
it's
lease,
been flooded.
it's the lot that you're leasing.
Right.
You're really not even, that's like a prohibition. I would, I don't.
Or I'm
think-
saying you, in Act 181, you added language that said if you're selling a
Mhm.
mobile home itself,
Right,
you have to indicate
You
whether
have
or
to
not.
tell
has
whether it had been flooded.
So that would be kind of similar.
But
to
it's
what
the
we
lease
have.
of the lot that's the
The
concern,
mobile
I think
home
that.
parks owner has to notify someone who is leasing a lot
yeah,
whether the mobile home park is located in a area.
in a
And,
FEMA map flood.
the language is slightly different, but
Okay.
essentially, yes.
So we have, unless we want to go into this wholesale, I would leave us where we are and just solve the problem we're dealing with now. If it arises or we flag it for mobile home parks, we can change it next year. But let's see if this change helps. Peter, you have a thought?
Yep, and just one thought is that, you know, the language for rental properties and mobile home parks does not include this penalty section that's in the sale part, you know. So-
That's true.
That
So,
is-
you know, while
That's true, that's a really
they're
good
no
point.
better or worse, you
Yeah.
know, the risk to the seller is much more consequential
Right.
than the other disclosures.
Right.
For
And it's a good point in that we have landlord tenant law that then requires the landlord to be responsible for flooding and damage, et cetera. I just wanted to make sure I closed the loop on
Yeah, no, I appreciate it.
all
I'm
areas.
still concerned about larger pieces of property. Somebody sold a farm, and you got, you know, a quarter acre, and it's subject to flooding down in the corner someplace. But you've had no flooding of the farm buildings, no flooding of the residents, no flooding of the barn or anything else. Making a disclosure like this, I just have a question about.
That's
So
what,
what's
Gabe-
the problem? What's the problem knowing that corner of your property is?
Well, the
I
one
would
thing is,
want
the
to know.
larger the property, you may not even know it.
No, but leading them towards the FEMA map, so at least they're aware.
Well, basically, you've given them the maps and so on. I'm talking about paragraph 3, whether the real property was subject to flooding or flood damage while the seller possessed it, including flood damage from,
So
and
they
so
say
on.
yes, that corner
Yeah.
or that, it's still benign.
If you know about it.
Yeah.
If I may,
Peter.
our plan with the disclosure that we're gonna provide for sellers is to have an explanation box, so that, you know, being able to say, you know, one corner of the property flooded and, you know, none of the buildings flooded would be part of that explanation.
right,
So, you know, it's always in an effort to provide, you know, complete disclosure.
Yeah,
And, you know, I'm thinking about a farm that's got a 100-acre field that does flood. I mean, that may impact the buyer's interest in
Yeah.
the property.
it's true. They
So-
need to know.
You know, but your point is well taken, that real property defines the entire property.
Yeah.
It is not just subject to the buildings.
we did have that conversation last year because Senator Cummings kept talking about the ravine that forms in her backyard every time they were flooding.
I think I remember that.
Yeah.
So I think we need to pivot to John Cam.
Yes, ma'am.
We could have a new draft of this tomorrow or Thursday morning. Thursday morning?
Thursday morning. would
Because I think we're gonna do cannabis most of tomorrow, which we have to get at, and it's gonna be a harder land.
Do you want help with the
The
intent?
intent.
I will
sentence?
draft it, and then I agree
Would you
with
run
your
it
comment,
by-
Ron,
Would you run
it
it by
will need your,
Randy, who's asked for it,
It will
or
need
all of us, actually? and we can
your,
take a peek.
tweaking to make
Right.
sure I'm capturing what your intent is, because it would be the intent of the body, not an individual, so.
Yeah, so let's start at 9.
With
So
this.
let's start at 9 on Thursday morning with this, if that's okay. Does that work?
Yes, ma'am,
Great, and you'll send intent language to us and everybody can weigh in.
sounds good.
Terrific. Thank you very much. Much appreciated. And we're also on Thursday morning gonna look at where we are with our appointments. And if people can weigh in, Heidi's also gonna give us the full list of the appointments, which we may or may not have been given. Because as far as I know, we've only been given 3 that I knew about. And David and Keisha and I have, and Randy has 4. Okay, so let's try and touch base with the people, because what I'd just like to hear is a couple sentences on if they want to do this, and if they sound great, then okay. Okay, great. Thank you, Cam.
You're welcome.
Peter, thank you very much.
Thanks,
Chris,
committee. Appreciate it.
thank you. Yeah, let's make this workable. John, welcome.
John Gray, Office of Legislative Counsel. So,
You're here for a CHIP update.
yes, my proposal would be, while I did share for posting the latest public draft from Ways and Means, will likely just get bogged down in language if I screen share. So I would propose just describing to you high-level changes if that works. The other thing I think worth noting is there's an expectation that this would be, the Ways and Means would have voted by today, and that has not happened.
I was gonna say, I don't believe that's happened.
So there is not yet a final version to reference, but I can tell you what the latest public draft from Friday does.
Can I ask just for clarification? This is attached to which bill? is it?
Our bill, S-127, which is probably gonna be, it's the one that's traveling through the House at the moment. And it's gone to all the committees of jurisdiction, saved Ways and Means. CHIP is in Ways and Means jurisdiction. So everybody has weighed into it. Commerce and General have weighed in, and Natural Resources in a little bit. And then,
Wait,
so now
can
it's
you
in.
say that again?
So all the other committees of jurisdiction,
Mhm.
General, the primary ones being Commerce and General, have
Mhm.
weighed in and sent it to Ways and Means, Ways and Means has been wrestling with CHIP for a week or two.
And you're saying that CHIP in its entirety is Ways and Means jurisdiction?
I can explain the path it's traveled. So House General had possession of the bill,
I think I know the path it's traveled.
but Commerce, without having possession of the bill, looked at the CHIP language for maybe a week or so. House Environment for a day looked at something, and then now the bill has moved out of House General to House Ways and Means, which is just looking at the CHIP section of the proposal. But House Commerce and House General both looked at CHIP, and so did Environment.
Well, and the CHIP language on the House side originated in housing in general.
Yes, yep, that's where it started.
Yeah, that's because it originated with us. So it went straight to House General.
And in terms of just duration, the two committees that spent the most time are Commerce and Ways and Means on the CHIP part, not to say S-127 as a whole.
And is it fair to say Commerce supported most of our language?
I think it's fair to say that they didn't disrupt the structure of the bill as received from the Senate, and went through various iterations and would often back down from something. And then that proposal would be taken up by another committee, for instance. So affordability is something you can think of along those lines. Each committee has struggled with what to do with affordability. Let me describe some kind of big things within CHIP. So the first is what counts as housing development. As came across from the Senate, it was construction of buildings, right, on that housing development site. That's been expanded to include rehabilitation and renovation. So we pick up other purposes there. Another big piece here is what is the size of the housing development site? That's the site where you're fixing the OTB and generating the tax increment. The size of the housing development site in the Senate proposal was the parcel or parcels on which you're constructing that housing development, plus any immediately contiguous parcels. So you're picking up a broader bucket. The current proposal is just the parcel or parcels on which the development is occurring and not any immediately contiguous, meaning they have a smaller housing development site. It's a very tight section, just where the construction occurs.
Right, yikes.
The definition of improvements. The proposal from the Senate had been something that is quite close to almost exactly what TIF districts has, right? You say improvements and then you provide a non-exhaustive list of things that count as infrastructure. Those things can be financed with tax increment financing. The latest public draft does not provide a broad category infrastructure and then a non-exhaustive list. It provides outright an exhaustive list of things that can be financed. So it's things like wastewater, stormwater.
So they were much more
roads.
prescriptive.
Exactly. You can only do these things with tax increment financing. You can't get anything that's not listed here. It's an exhaustive list of permissible things being financed with TIF, which was first explored in House Commerce and then backed away from that proposal.
Trying to be less prescriptive.
Trying to be less prescriptive, and I think concerned about getting right the exhaustive list, because if you don't have something there, you can't you can't include it. Of course, you could in the future amend it, but that's sort of thing of that. A really light change to the purpose. It's mainly just a wording change, but the purpose currently is the purpose of the Community and Housing Infrastructure Program is to support the development of new primary residences for households of lower moderate income. So very much like what was proposed here. But then it has this last clause that would not be created but for the infrastructure improvements funded by the program. So it's not as strong as but for language in a but for test, which will come later, but it's just saying this is about supporting primary residences for households of low to moderate income that wouldn't have been produced if we didn't have this program. That's what the purpose is. So quite similar to what came across, but it includes that.
And how do we prove that?
You don't have to prove anything there, it's just a purpose section.
Right.
But we will come to the but for test because there is a but for test. So there's an additional update to, you'll recall, there's a process that a municipality goes through to create its project plus the housing development site. And one of the things it does is it develops a housing development plan, which describes the timeline, what's being created, how it's being financed. There's been one additional addition to that housing development plan, which is a requirement that the municipality include in that plan a determination that the proposed housing development would further the purposes of the program. So they need to say, basically, we stand by the idea that what we're pursuing here is backed by the purpose of the program. There is a primary residence requirement, and this is built into
Of the developer or of the people living in it?
So the way that it would work is it builds into you'll recall the housing infrastructure agreement, which is the contract that governs the relationship between the developer, the municipality, and potentially a third-party sponsor. Building into that housing infrastructure agreement a requirement that housing units produced through this program be offered as primary residences in perpetuity. So the idea is that these would only go to folks who are going to make these their long-term home. And it's built into, like I said, it's built into the housing infrastructure agreement. So the thinking there is that people will build into, for instance, like covenants, a requirement that they be offered only on that basis.
That causes me some concern. I just think about apartment complexes, and we need high density housing. So what that would work against what a lot of this is intent.
It would not prevent rentals, just to be clear.
Okay.
A rental could be to someone where that's their primary residence, but what it would prevent is like a second home or short-term
Right.
rentals out of the.
But it is requiring the municipality to enforce that.
It doesn't require the municipality to enforce it. The way that it works is it provides general terms within the housing infrastructure agreement. So it's not prescriptive as to the specific means that people use to achieve this, but the natural place would be covenants. So the contractual relationship between the purchaser and
So
the developer. And
VHCB did this and
you could do this through an HOA, which is, I think, a common way that people do things of this kind, but it is not prescriptive as to the specific means as to which this is achieved. It just says, make sure you include terms in your agreement that ensures these are offered on that basis.
So this is where I would go back to the major change that Ways and Means made in housing policy in the property tax proposal, which is defining a rental at 6 months in the property tax proposal. That's a huge change. And not one that,
at a minimum of 6 months.
yeah, that's, the current law is you proffer a landlord certificate at 1 month. And 1 month for many other renters' rights purposes and many other, all of our housing law is predicated on a residential rental being 1 month or more. So this is where I worry that the jurisdiction of defining what a rental unit is something we should look at very carefully for unintended consequences. And I don't think we want to put covenants on housing.
Well, we do put covenants on.
Tell me more about what you mean by that.
We put covenants on housing, the HCB does with houses that have to be sustainably affordable, and those are covenants, aren't they?
There are programs that use
Yeah.
covenants, sure.
I mean, Becca's house is under covenants.
You mean shared equity home ownership?
Yeah, that's a covenant.
That's not a covenant.
I thought it was.
That's not simply a covenant about who can buy the house.
No, No, but it's a covenant about the affordability of the house.
That's not what a
It's going
covenant
off into
is.
perpetuity.
It's not a covenant.
So
Then I don't understand.
some programs do, some programs don't. So for instance, for achieving affordability, we have housing subsidy covenants, which are something that can be
they are.
negotiated to ensure perpetual affordability or time-limited affordability, whatever you might want to do.
Yeah, I thought those were referred to as covenants.
But I just want to be clear that the language that's in the draft is leaving to the parties to figure out the best contractual way to ensure that this happens. The discussion has been that that would be the natural way to do it. But it's admittedly a bit outside my bailiwick. I don't,
So why don't you finish on the big picture and then we'll
Yep.
zero in on the things we're concerned about.
Yep. As came across from the Senate, there was a sunset, a final application deadline at the end of 2035. That's been accelerated to be 2030. So you can think of it as like a 5-year pilot program is probably the natural way to think about this. They've added a but-for test. So it's the same but-for test as applies for TIF districts, but would be using the defined terms that are applicable here. The project criterion, as came across from the Senate, was that the housing development include housing. You'll recall in those final days, we went back and
Yes,
forth
we
on
went
thresholds
back.
and the like, and just landed on includes housing. The project criterion here is that the housing development provide at least 65% of floor area to housing. So 65% of the floor area be dedicated to housing. For location criteria, there are 2 different places to note. Upon effectiveness, the location criteria would be limited to that Tier 1A, 1B, or interim housing exemptions, which is the first location criterion that came across from the Senate, and existing settlement plus that 1/2 mile, but would not include a Tier 2, or you'll recall we had a proxy for the Tier 2 in the
Right.
years leading up to it, which was letter from the RPC basically in support.
So they now have no tier 2.
They have no Tier 2 until on January 1, 2028, you would replace that existing settlement criterion with the Tier 2. So basically that's a year out from what is expected to be the earliest date that those designations would be available. But at the start, no Tier 2, and then at the start of 2028, you would then have available Tier 2 as a location criterion.
2028 is a long time away.
After the maps have been, so that's, okay, keep going.
Affordability. So there is no affordability requirement across all projects, but there's an incentive structure that's created to target affordability. So the way that the proposal works, it provides an extra education property tax increment to affordable housing development. So the education property tax increments that are proposed in the bill are up to 60% of the statewide education property tax increment if you don't meet the affordability criterion, and then you could access an additional 20% increment if you met that affordability piece.
So that,
So you could get 80%.
I just hope we can level set, like we tried to create this for small communities like Fairhaven to take advantage of.
Or Reading.
And I don't even understand it anymore. So, I almost want to just, like,
Sounds incredibly complex.
it's the Rube Goldberg of tax programs. And have we even talked about the fact that they rolled back TIF, the original TIF program? We have a
I can say that now.
Why don't you finish, and then we can,
Yeah, that's
and then
fine.
we're identifying the areas that we're having a hairy canary about.
And just to call out what an affordable housing development would be under this incentive structure, it's a housing development of which at least 20% of the units are subject to a housing subsidy covenant, which is in Title 27. I can give you the references if helpful, but a housing subsidy covenant of perpetual duration, which is something that affordable housing developers currently use to provide for affordable housing. So that would be, if you wanted to access this additional 20% increment, you would have to provide at least 20% of your units within the housing development subject to that perpetual housing subsidy covenant.
But is that different than what we do with, I have to talk to Chris Donnelly about this, because we have determined that perpetual affordability requires huge investments that you are not getting from any rent increase on the tenants.
Where you have to account for it, yeah.
Right.
So I don't know that we need to look at that section.
You sure do.
Yeah, and I will say that, when, this concept was included, it was, me working with Chris Donnelly to use this specific, definition, but the economic question would remain, yeah. And the places to look would be the first two definitions, which are affordable housing development. And then you could look at the project criterion, which just says this is available if you are an affordable housing development. So it's really the first two definitions. Okay, the next piece is this idea of a CHIP board. So there's a separate board. This
Than
would,
Pepsi, different than Pepsi.
exactly. I can tell you the membership of the board includes the chair.
Chair board.
Yep, and I'll explain what the role is, but let me just tell you the membership first, or I can explain the role. The role is kind of like a double check on BEPC's work. So BEPC does its standard application process, reviews, and then the board receives a recommendation from BEPC that this application looks good to them. And they compare it against the purpose of the statute and then confirm that all the criteria have been met. And then BEPC could then approve the tax increment financing for the projects that the board has signed up on. The membership would be the chair of the BEPC board, and then note for all of these, you can have a designee. So this isn't personal to them. So BEPC, treasurer, VHFA, VHCB, DHCD, bond bank, council on rural development, a representative of the RPCs, and the VSBA, the School Boards Association. And just to explain why they chose this membership, the thinking was for housing expertise. And then obviously they wanted like an education piece here to get at the impact on Ed Fund. But that is the CHIP board proposal. Again, the role is it's like the final step in that.
VSBA is the School Boards Association?
Yes.
Yeah.
Yeah, no, and
Okay.
Yep. The other members, you can see the tie to housing, but yeah, and that is
and the role is to be the housing lens for BEPC.
exactly. I think it came from, that these parties might be better equipped to make an analysis of whether this is serving the housing needs of communities, but
And
The
I
idea is
don't
to
think
serve as a
BEPC is qualified to do that at the moment.
I'm not gonna.
Yeah, I don't think we should ask you to explain.
Yeah,
to
okay,
what
so
all
keep
this is.
going,
There's a cap proposed, and this is the hardest thing to explain to people, but it's a yearly cap on what can be approved in that year. So each year, BEPC would receive sets of applications for projects, and those applications would contain the tax increment financing plan for each of the projects, right? So you could tell from that tax increment financing plan what the projected total education property tax increment retention is meant to be across the life of the project. And so you could have one that says, I'm gonna use up 3 million in, over the lifetime of the project, not in a given year, but I'll use up this.
so to cap on the increment withholding.
Exactly, and the cap is an annual approval cap of 40 million in lifetime. So what that means is in a year, as you receive applications, you cannot approve more than 40 million in lifetime aggregated across the applicants for that year. And the reason that number was chosen is that is the number that is projected based on a set of basic assumptions. So we don't know empirically if this is the way it will work, but that is the number that is projected to result in a maximum yearly impact of a 1 cent increase on your statewide education property tax. So that's where the figure comes from. But it's an annual cap. BEPC can approve applications in the year until it hits that cap that would result in 40
So the
million.
cap isn't on the number of projects,
Nope.
it's instead on the increment that is withheld,
Exactly,
or from their perception,
exactly,
withheld from their.
exactly.
Of course, their steady state on what was already contributed.
Yes,
So there's nothing that's being withheld, so it's an interesting concept.
so that's.
Okay, anything else?
Yep. a few
So
other
cap
things.
on project, cap on increment.
We've already talked about the property tax increments, but I'll just hit them again to remind you. I talked about this in the affordability context. For your standard project that doesn't meet an affordability criterion, for the statewide education property tax increment, their retention percentage is 60%. If you have that affordability, you can access an 80%, so you get an extra 20%. In both cases, the municipal property tax increment is not less than 85%. You'll recall that as came across from the Senate, there has been, for the statewide education property tax, an 80% increment retention, and for the municipal, not less than 100. I would note that the municipal is maybe less, it's a not less than, so not less than 85, you still have 100% of dedicated increment there. One technical provision that this includes that TIF district does use is an adjustment of percentage. So for TIF districts, BEPC has the authority in the 10th year following creation of a district to downward amend the retention percentages if they determine basically that the community is receiving sufficient increment to cover the cost of the debt. They don't really need to retain as much as they are. This provides the same mechanism, but it's a 5-year check-in. I don't know how likely, particularly given the size of the site, you're going to be able to be in a position to downward amend, but it's at least making available that if they can downward amend the retention percentage and still protect the municipality's ability to cover the cost of financing, that would be something that BEPC's authorized to do, and it would be a 5-year check-in. Last couple things, to the annual reporting pieces, the proposal adds to that list of items for reporting expected or actual sale or rental prices of housing units, any units that are known to be occupied on a basis other than as a primary residence. I would note that the mens rea there, the mental state required, is known, so it doesn't require a municipality to go out and investigate that this is the case. It just says if they are aware. This was something we would have to report. And lastly, the latest request was an evaluation of the amount of public funds that were flowing to private ownership or usage. So those are your updates to annual reporting. The rulemaking has been expanded in 2 ways. So there was a broad grant of rulemaking authority on the Senate side, much like what is done for TIF districts. Same applies in the proposal as you see in the House currently, but also provides specific directives to develop rules to govern the prioritization of applications. And if you think about imposing a cap, that means there may be a rush on the program to get in before you hit the cap. So you need to have some kind of prioritization mechanism to deal with that. So it tasked BEPC with adopting rules to deal with that, and also for determining what the appropriate floor area measure is for the project criterion roll call. We've talked about gross floor area, usable space, and the like. They're just tasking it to BEPC to figure out what an appropriate measure would be. The other substantive change here is that this would require BEPC to submit a copy of draft rules to the Joint Fiscal Committee for review at least 45 days prior to pre-filing with ICAR, and then the final piece, which was touched on earlier, is the TIF district sunsetting. So this would end new applications. It wouldn't end. The
CHIP district.
No, this is for TIF districts. So all of the stuff we talked about thus far is CHIP. This last piece is what Senator Ron Hinsdale was getting at before.
And what's the requirement here?
This would, sunset TIF districts is basically the thing that it does. It doesn't end existing districts. What it does is say no new applications. I think the latest public draft is immediate, it's July 1/25. So basically the way to think about the current public draft is that it would replace TIF districts with the CHIP program. And that is all that I have for you, just small set of changes.
Yeah.
Cheese and crow.
It hasn't voted out, sorry.
It is not.
Yes, Thomas.
So it has not voted out of Ways and Means. What percentage of these changes were applied by Ways and Means?
Percentage.
I can quickly try to explain, but
I'd say 90%.
It's noon. I don't know if you're gonna get to a
Yeah,
percentage.
a
in
large
30
amount of them.
seconds.
90%.
The primary residence doesn't come from them, but Commerce had a primary residence in perpetuity. House General made it to initial offer, just need to be primary residence, and then they moved it back to in perpetuity.
But they don't define that with a landlord certificate or a homestead declaration.
The 65% threshold is actually, a floor area is actually lower than what came out of House General, but House General had provided a backup option for if folks didn't meet the floor threshold, and that was actually the genesis of the board. The board was in the House General proposal, basically a way of saying if someone comes in the door and can't meet the floor area threshold, they can ask this board to say, we think that this meaningfully contributes to the housing needs of the community. And that was the sole role that that board had, was just to step in and make that determination. But you can see quite different role here.
I just want to say that one of the biggest policy concerns and I feel like some South Burlington folks can attest to this, in talking about floor area versus number of units, is that you can have huge units and incentivize that over getting multifamily housing. So, are you not following?
So large floor space, one would assume would be, I see.
You
But
can't
they would
assume
still
that.
be single, they would still be
You-
single
if-
ownership as opposed to many more.
That
small
could have nothing
Right.
to do with the number of units. If they then have to create affordable units and spend money on that and not get any additional funds on that, which I would say this committee has determined is a very significant policy choice that often squeezes middle-class purchasers, then you might get that extra floor space from very large units that give people lots of bedrooms they don't need, instead of creating incentives for density.
I agree.
This is all housing policy.
Yeah.
I have a lot of concerns with what was presented. I'd want a lot more testimony than
Yeah.
15 minutes before I
No,
speak.
we're done, we need to.
But
we
it
need
also
to be
hasn't
done.
passed.
So I just wanted us all to get a notion of what's coming at us.
Sure.
I mean, it hasn't actually been voted
I was
out.
gonna say, and just a
Yeah.
caution, it may not be what comes to you.
I
Yeah.
would doubt it.
It'll be something similar to this. And.
Do you think so?
Unless the miracle happens. I mean, I can't imagine, I mean, the plan was to just go in at 9 and vote it, but that clearly didn't happen.
But it also has to go through the floor.
Oh, absolutely, and I don't think this will make it through the floor intact. But I also am puzzled because I know that the committee was supposed to vote on this at 9 and they didn't, right?
That's great. Yeah.
So clearly there may be some changes afoot. So
There may
thank
be.
you. So this was great. This begins to prepare us. And
Good.
I am very grateful and we'll look forward to hearing, well, I'm not sure we look forward to hearing anything.
Time has passed.